mention a matter. By order dated 10/11/2025 of Lordship, CC 96 of 25 was disposed of. But from that date, 7 days has passed, so a drawn up was not done. I beg Lordship's leave to kindly allow the drawn up so that we can apply for the certified copy, Lordship.
Milord, it's a abnormal against the abnormal fee hikes by the private school, and it's almost 1 year, and abnormal fee hikes is affecting the parents of.
Yes, please.
My lord, on the extreme emergency, my lord, may we permit to mention one matter for upgradation, my lord. What has happened?
No upgradations and no inclusions, please.
My lord, if my lord, may I please, my lord, this petitioner has been without any notice of hearing. He has been not allowed to join in duty as a teacher, and he has been show cause and without any procedural formalities.
There is a day for upgradation and inclusions. You could have come on that day.
My lord, I came last month, my lord, your lordship directed me to come again this month, my lord.
This month also, every month there is a day specified. All right. Yes, please.
One correction, but initially matter was passed over. Now, usually a lot of election was passing. Now, in the YouTube, in the your lordship will think that I was there. Now, subsequently,
your name has not gone down.
I was in that side. Mr. Pradip, the court officer was there. He knows that. I was in that side.
No, what happened? Your name has not gone down. If
Lordship, correction of your lordship, sort of.
What?
Correction of the petitioner's name, your lordship.
Petitioner's name?
Yes.
If
Small correction, my lord. Petitioner's name. I have already corrected.
If yes.
Item number 1, 2.
All right.
Item number 1. But yesterday I mentioned for releasing of the matter, your lordship. I am for the school authority in this matter. I mentioned before Judge Rai Chattopadhyay, mentioning was allowed, searching slip was sent, requisition slip was sent, but it was all on a sudden as a old matter appeared before your lordship.
All right.
But I was served with notice that it would be mentioned in another court.
All right.
But I won't be
advocate for the petitioner submits that this matter has been mentioned for inclusion before Hon'ble Justice Rai Chattopadhyay. In view of the above, let the matter stand released from the list of this bench.
Grateful, madam.
Yes, respondent school. গুলোকে দিয়ে দেবেন, স্লিপ থাকছে না কিন্তু ভেতরে, না তলায় দিয়ে দিতে।
My name has not been recorded, my lord. 2, 3 and 4. I'm for the commission, my lord.
All right, your name has not been recorded.
Yes.
Name of the learned advocate for the commission has not been recorded. Please do the correction. Items 2, 3 and 4.
Yes, great.
Right. Say order.
Great.
Time for the petition. Pursuant to your lordship's order.
Number 5 is not this. It's a 4 দিয়েছেন.
It is fixed to 5.
Yes.
Pursuant to your lordship's order, my lord, the petitioner went to the school, submitted his documents. My lord, the school is supposed to apprise. They are going to recommend or no.
Where is Mr. Bagh?
Mr. Bagh is
Call him, I'm passing it over.
Yes, Lordship.
Yesterday, did you not mention your name because I do not see your name in the order sheet?
Probably someone missed. Doesn't matter.
Doesn't matter, but you were there. His name should have been there.
Probably my advocate on records forgot to mention in the.
Hmm. I'm passing it over for the time being. Please bring Mr. Bag. Call the next matter.
My lord, item number 6 to 9, my lord. These are relating to, my lord, students, shortage of attendance, CBSE exam.
Is the school a party of the same school?
Yes, yes. Unta 6 affidavit of
Delhi Public School.
Delhi Public School.
I'm from the school authority, madam.
All right.
Forward lagara tumi tapiyo karo.
Sir, I will
Not
not.
be here. No instruction. Did you serve CBSE?
Yes, lagbe. Yes, I have served, my lord.
Without you, the matter cannot be heard.
তুমি ছাড়া হবে না।
What is the stand of the school?
Well, according to rules, my lord, there is no scope to attend on the examination, my lord. There is rules, my lord, CBSE.
What is the percentage of?
My lord, here, my lord.
75%, my lord.
My lord,
No, what is the shortfall?
73.
No,
To place, my lord, the regulations, thereafter your lordship can amake regulation.
68%.
আমাদের copy. My lord, regulation 13 first, thereafter.
Yesterday all these were placed.
Actually, my lord, actually 68% preference is there, my lord.
68.
68%. Only first student, my lord. There is first student.
May I suggest one thing? Let's have a copy. I will take instruction. I'll come back at 2 o'clock.
Right, that will be better.
Yes.
Survey copy?
Yes.
2 o'clock? Because
So, there
yes,
is a matter fixed, my lord.
I'll take it prior to that because this is more urgent.
Yes, ma'am.
Got it?
That's
2 o'clock, দুটো সময় ডাকবেন। 6, 7 and 8.
8, 9 to
9 also?
9.
9 also? Alright, 6 to 9.
Well, my lord, I am for the respondent.
এটা পুরো
এটা কোনটা দিলেন? এটা কোনটা দিলেন?
পুরো
Item
12?
শুভেন্দু ব্যানার্জি
Dismiss for default. সরান এটা। হ্যাঁ, dismissed.
item 12 I am for the commission, huh?
Item 12.
এটা নিন
item number 18.
That is, my lord, I am for the petition, my lord.
What is the matter?
Transfer matter, my lord.
Who is the other side? Yes, what is the ground for?
My lord, the petitioner was appointed in the year 2013 in the school, my lord.
Where is your application for transfer?
My lord, kindly see page, my lord, 17. This is my application. Annex R P5.
Not in the prescribed format.
No, my lord.
Why not? Please come. The petitioner seeks transfer. Stop. It appears that he is yet to apply in the prescribed format. Stop. Next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply for transfer in the prescribed format. বলে usual যে অর্ডারটা আছে fresh application ওটা দিয়ে দেবেন। Disposed. Next.
May I submit the affidavit of service?
My lord, I am for the petitioner item number 4. Appearance in 14 days.
14.
I am for the petitioner. The assistant teacher, my lord, filed a writ petition against the headmaster.
One of the private
He has eligibility. He has annexed the check that for transfer he has taken check of 40,000 for everything. He is taking check and no financial committee. My lord, there are several bank accounts in the.
Did you raise a complaint?
Yes, my lord, I
Where is
raised a complaint twice. Board forwarded it to the DI for action taken report and report back to the board. Nothing has happened. Twice, my lord.
Please show.
Yes, my lord. First, my lord, page 27, my lord.
Yes. Where is the forwarding by the board and the
Lord, page 27, if your lordship kindly.
27?
My lord, may I place to the DI of schools
Hmm.
in making, in inviting your kind attention to the letter dated of some assistant teachers of Swanfield school, my lord. You are hereby requested to send the action taken report on the undersigned immediately while. My lord, this was way back in 2018, nothing
Right.
happened. The আরেকটাও complaint আছে আরেকটা complaint আছে last date হলো আরেকটা ফরওয়ার্ড করেছি again my lord I gave a representation page 116.
Did the DI do anything?
Oh my lord.
Yes,
DI has
did something.
what?
I am
Are you
agreeing
representing?
headmaster of the
My lord, against him is
but
Master of this school is respondent number.
16.
All right.
15, my lord. 15.
But
On Pyra.
yes,
Hmm.
this matter is mentioned without providing notice to me.
All right.
But whatever the thing is that the allegation as there, it has been dealt by ADI on the request of the kindly see
And then it has been forwarded to the, please pass on, it has been forwarded to the board.
board. Board ke forward ko.
ওটা কি হতে তো
এগুলো দেওয়া আছে। এটা board ke forward করেনি।
Copy was forwarded to the DI.
DI. As because DI put a notice to the ADI to conduct inquiry.
Yes, yes, I
Inquiry was
follow.
there, and the allegations as there in the writ petition not substantiated.
Right.
So I will come back with an affidavit if your lordship kindly direct me.
Are you aware of this?
no my lord nothing.
No?
My lord, only one thing, my lord, this is a supplementary affidavit. My lord,
Then I
kindly-
don't get that.
Yes, my lord, kindly come to page. আমার কাছে কপি আছে my lord, kindly come to page
Your lordship
30.
kindly direct him to
Page
start the
30.
supplementary affidavit.
Mm-hmm. Yes, page.
30.
Yes.
My lord, kindly see.
Check.
He is an assistant teacher, check to the headmaster 40,000. There are, I have also annexed all the bank accounts. How much money in different accounts? Why an assistant teacher will give a check of every, I have given every allegations that, and my lord,
Who is this Indrani boy?
my lord, he is one of the assistant teacher for single teacher transfer. She has to pay that. And my lord, one of the assistant teacher has retired.
And has this check been encashed?
Yes, my lord, that also I have annexed, my lord.
So far the supplementary affidavit right now I got, I don't have any instructions. So kindly direct me to file affidavit in opposition. And so far the allegations in the writ petition that I have handed over, that it has been taken care of.
Alright, supplementary affidavit filed in court is taken on record.
I am appearing for one of the private respondents.
Yes.
Being respondent number 18. I am a
Correct.
retired teacher presently, but the petitioner has tried to read out a case where I am also supporting the same cause because something has happened with me also, for which I have preferred a writ petition. But since I have been made a private respondent, it was something like that a bribe was asked from me.
Alright, where is your writ petition?
This is the writ petition earlier
Number
and there this respondent number 15, I have handed over the order. Order of the earlier writ petition, the final is
2 of 2025, Your Worship.
and there is,
Pinapani Manna Maiti.
Mileage.
yes, and there I am stand as a respondent number 4.
Encashment, Your Lordship will find at page 12 of the supplementary affidavit.
So your
16. 14 and 16.
There I also stand as a 14 and 16 a respondent in the writ petition. And I have already filed a opposition.
Consultancy.
The opposition filed. I have already filed opposition.
alright. Filed by the petitioner in court today is taken on record. Stop. Let copy of the same be circulated
My lord, it has been.
to all the parties. Stop. Is the board here today? No. I'm here, but my copy not served. Alright.
Writ petition.
Acha. Learned advocate representing the respondent number 15 submits that an inquiry was that as per the direction of the district inspector of schools, the additional district inspector of schools secondary education Kharagpur subdivision conducted an inquiry and forwarded a report to the DI on 23rd of September 2024. And forwarded the report dated 23rd September 2024 to the DI with a communication dated 3rd October 2024. ঠিক আছে? Stop. Learned advocate representing the respondent number 18 submits that though allegation has been made by the petitioner against the respondent number 18, but the respondent number 18 supports the case of the petitioner. Stop. It has been submitted that the respondent number 18 was also subjected to pay fine, not fine, pay bribe to the headmaster of the school. Stop. A writ petition filed by the respondent number 18 is pending disposal. Stop paragraph. Learned advocate representing the board is yet to receive instruction. Stop. Next. In view of the above, hearing of the writ petition stands adjourned. Stop. The respondent number 15. How come there are two respondent number 15?
Typographical mistake.
15A করে দিন ওপরেরটা তো 15A করবেন হেডমাস্টার যেখানে যেখানে 15 বলেছি it should be read as 15A হ্যাঁ the headmaster
Yes.
and the private respondent number 18 are directed to file affidavit disclosing their stand, annexing all documents in support thereof. Stop. Learned advocate representing the state and the board shall obtain written instruction from their respective clients. Stop. Such affidavit shall be prepared and circulated by 13th of March released on 27th March.
My service and court fees.
Alright. ঠিক আছে। 27 March along with WPA 18222 of 2025. Binapani Manna Maiti versus State of West Bengal and others. Order sheet is here, please check. Leave is granted. Acha, affidavit of service and the deficit court fees be retained with the records. And leave is granted to the advocate on record of the petitioner to correct the serial number of the respondent in the cross title of the writ petition. Stop. The headmaster shall be referred to as 15 caps A. Is he on record here?
Yes.
Shoma Mal.
Yes.
Then let it be corrected. This you can take back.
One indulgence, there was a
Yes,
direction
please.
in the order that was passed in my writ petition that I referred that there was a direction
Opposition.
position.
already
Service continue.
Check up. If you want to file a reply, there is already a direction file it.
I will comply it by the grateful.
Yes.
I'm sorry, Papa. No, take it up.
Is all the party there?
Yes.
দেখি 5 নম্বরটা
Statement will have made by the principal in compliance.
এই যে আমার কাছে ফাইল ফাইল ইজ হিয়ার what allowed
Practically, principal stated that if he is allowed them by the principal, then it would set a bad precedence.
all right
That's why if it becomes a court's order, he has no problem, he will carry out the order. Practically not so far academic matter is concerned, in keyboard exam.
absolutely the merit of the student is
I cannot improve.
I understand. Oh, why doesn't he stay back
But he wants to appear in the examination.
and fail?
I have seen the last year's.
The percentage of marks is here.
Yes, I have seen. But
And have the copy.
the question is of attendance. In class 11, he attended 87.
Listen, the question is of attendance because the child did not attend the school. He is bad in his studies. It is as simple as
Here
this.
his attendance was 87%. Despite that, his marks was around average.
50. But see, in the next 38%, 40%, 37%.
That I have seen.
Why? Let the candidate stay back.
Kindly considers.
I am considering it.
And,
And it will be good for the student only.
Right.
Isn't it?
My lord, there are judgments also, my lord, sympathy.
Yes, yes.
We have full sympathy to him, but
My lord, I tell your lordship, we have reports that this principal of this school is very strict and very efficient and very, my lord, responsible.
So,
And
where is Mr. Ahmed? Will you appear?
he is appearing in court number 2.
All right. 2 o'clock I will take up. Because other matters are also there at 2. I'll take this up at 2. But please tell Mr. Ahmed that this is the view of the court. This is Kendra Vidyalaya school.
got it.
All right. Let it remain 2 o'clock.
I could not appear. Learned friend is appearing. I'm sorry,
No, 12 has been space.
One indulgence.
sorry, I could not.
At 2 million fixed matter is a court number 15. If it is taken up at the first instance, then we will have.
Yes, first instance.
But I am here, my lord.
12 নম্বরটা একটু দেখি
The matter relates to my transfer, my lord. The petitioner is the disabled person, my lord, 60% disability, page 9, my lord. he prayed for transfer within the his area, my lord. He was posted assistant teacher in the district of Purva Medinipur, my lord. Representation is at page 17, my lord.
17?
17. But I am praying for consideration of the representation, lordship.
But then transfer cannot be done by way of a representation.
But he
Please come.
total, my lord, he page 13, my lord.
The petitioner claims to be a physically disabled. She seeks transfer.
School service commission? Well, service commission for the server not.
No, sir, my lord, I have, sir. Evidence, sir.
Saurabh Mitra Malot is appearing. Mr. Mitra Malot.
ওনার অ্যাপিয়ারেন্স রেকর্ড করে নেব, ঠিক আছে?
আমি বলে দিই।
আর it appears that the transfer stop she is yet to apply in the prescribed format. একটা অর্ডার সকালবেলা দিলাম, সেই অর্ডারটা করে দেবেন। You apply in the format.
But page 13, my transfer application status is there. But online application she has made, man.
Oh, you made online
Yes,
application?
my page 13, lordship.
Oh, আচ্ছা দাঁড়ান।
But let it be considered.
Has joined on administrative ground and we got after 9 years of creation of only assistant teacher in history.
My lord.
Single teacher order দেবেন। She is yet to apply হবে না। Her application seeking transfer was forwarded by the head of the institution to the DI on 6th October 2022 with the remark that she is the only assistant teacher in history in the HS section. Only assistant teacher in history?
Yes.
HS section, ঠিক আছে? Stop. The petitioner presses for transfer. বলে single teacher দেবেন। রূপক দোহা যেটা আছে।
Pending before the
Single teacher pending before the DI. Are you still a single teacher?
Yes. That,
You do not know. In that
well, let it be considered by the TR, my lord. Since
কি বলে ওটাকে?
লিখেছি সিঙ্গেল কি তখন ছিল
Fresh application to be made. Considerable period of time has elapsed. সেই পিরিয়ডটা দিয়ে fresh application to be made. রূপক দোহা দেবেন। All right, disposed. Service is taken on record.
Back to appear from the state, my lord.
My lord, the matter relates to CPF to GPF, my lord. But my lord, the petition is covered by Muktimoi Pal's judgment, my lord.
Only the presentation only page 19 to the school only. My lord, let the DI consider the petition as a representation and consider.
Show me the order that you are relying upon.
My lord, I have corrected the order, my lord, and it to them, my lord.
And
My lord, the Muktimoi Pal judgment.
no, I do not want Muktimoi. All right, this order disposed of. Service taken on record.
and for the statement.
And for the school service. The petition is that TET qualified DLED
candidate participated in the selection process of 2016 upper primary. So the petitioner, after an application, he made representation with the School Service Commission that the DLED is the expert of the elementary education, upper primary will fall under the elementary education. But they have this qualification, so that they should be given the priority to appoint in the upper primary selection. He made representation, thereafter the moved before this Hon'ble Court, and Hon'ble Court was pleased to pass an order. Kindly see. To the page 83.
What is the order in the recent order sheet?
But there is no
Page
written
94.
order has been passed by the considering this order.
Is merit score as reflected in the?
No, there is the another issue. This is no reflection of the that order. This is the another. They made an application in terms of the division bench order passed by the order challenged by order passed by the Muslim Bhattacharya, and that order they have made the application for reason order. But there is the cut-off marks, which marks has been granted with the lower marks. So they have not got the appointment. In this case, my case is that the DLED candidate, whether they will be giving the first preference to be appointed in the upper primary panel. So that's
After
why
everything is over?
no. This is the 2020. This is the ongoing process. I have made representation. Repetition was moved earlier occasion, and thereafter again I made the representation on kindly see page 84. Now and I have stated in the paragraph 22, I have stated in this that the B.Ed has given the preference to the appointment for the post of upper primary.
Not
But
DLED.
yes, that is the objection. This is the contention before the.
But tell me, after the process is over, will it be proper to enter into all these things?
Well settled principle. Your lordship.
Page 85 is your representation.
Yes, ma'am.
It was in the year 2021.
Yes.
You filed a writ petition in 2024. What were you doing so long?
This is the 21. That is order passed by the reason order passed by the division, and 89 is the next representation,
You go on filing representations, but then that is not the end of the issue. All these are of 21.
No. This is the representation after the passing the order of the reason order. Reason order I have challenged before the School Service Commission that they have not given the preference of the B.Ed.
Yes. This you've challenged the reason order, the awarding of marks you have challenged.
No, I have challenged the priority. What priorities we giving the B.Ed?
B.Ed have been given more marks?
Yes.
This is what you've challenged?
Yes.
In 21?
No, also I have representation made also after that, after passing the reason order. Is 89.
89 is by a different candidate. It has no date. It is by a different candidate.
There is there is no date, nothing of the sort.
No, 20.
Page 89.
85 also I made the representation,
Yes, 85 is 21. And the writ petition is filed in 24. What were you doing for so many years?
I have after publishing the panel, I have seen there is so many B.Ed candidates included in the panel. Kindly see paragraph 22.
Show me the recruitment rules. Is anything mentioned?
Yes,
That DLED
yes, there is a mention. Page 69,
Yes, 69.
Clause S.
Yes.
The upper primary means the general education above primary level till the completion of the elementary education in the meaning of the RT Act, admission of the secondary stage. The elementary education is and U, professional qualification. The 2 years diploma in elementary education. This is the first clause. The first clause, if the DLED candidate will not be available as per the NCT norms, the relaxation will be given to the state government.
Show me that the DLED is to be given preference over the B.Ed.
But because my lord, the B.Ed candidate, they have no knowledge about the elementary education.
I understand. You show me that the rules provide such.
Rules my lord, as per NCT norms my lord,
Your
upper primary and also my lord, the primary section, both are fall under the elementary education. This is the principle of
this rule is of 2016, right? If you are aggrieved that this portion is not there in the rules, then the rules are to be challenged.
well, until and unless my lord, the panel will be published. Well, I am not ascertain whether the delayed candidate will be given the preference or not. But
That
is
means
my
there is
philosophy.
nothing in the rules which mentions that DLED is to be given preference.
Yes, my lord, as per my lord, series of the my lord, the qualification.
Yes.
First preference my lord, the DLED.
Where is that?
My lord, clause U Roman 1.
Nothing. It includes as follows: 1, 2, 3, 4, 5, 6, 7, 8.
Because one of the elementary education is the one of the mandatory provision for the upper primary section. So one of B.Ed candidate have no knowledge about the elementary education.
I know petitioner participated in the upper primary.
Judgment.
And
First round got set aside. There are 4 petitioners here. Then the second round of recruitment started. Court directors to arrange for the personality test on one hand. On the other hand, to give grievance hearing to all candidates who approach. 18,000 candidates approached. The petitioners also approached. All 4 of them are below the cutoff. This grievance hearing was held in 2021. The personality tests were held in 2021.
Everything in 21.
Yes. And now they are coming up. Kindly see the last annexures, all 4 of them. First see page 86. This is of the petitioner number 1.
Yes, I have seen that.
21st September 2021 attended. Kindly see page 88. This is the calculation of his scores. Professional score has also been given 10, which is the highest score. Merit 71.46, where cutoff was 79. All 4 candidates.
All 4 I have seen.
All 4 have the same. So they are all unsuccessful in
candidates.
2021, and now in 2024 they are coming up with this repetition, trying to.
Points.
Yes, 20 court disposed of, passing certain orders. Anyway, I got it. Please come.
My lord, one thing, my lord, one
Charge.
statement, my lord, the
Participated in the recruitment process of upper primary teachers conducted by the West Bengal Central School Service Commission in the year 2016. Stop. The petitioners challenged the said recruitment process. Stop. Direction was passed upon the commission to provide opportunity of hearing to the aggrieved candidates. Stop. The petitioners were duly heard, and it was found that the petitioners secured less marks than the cutoff. Stop. For the same, the petitioners have been found to be unsuccessful in the said process. The petitioners, paragraph they are aggrieved by the same. Submission is that the candidates possessing DLED qualification ought to have been given preference over the candidates possessing B.Ed qualification. DLED, B.Ed. Yes, sir. Stop paragraph. The West Bengal School Service Commission, bracket open, selection for appointment to the posts of teachers from upper primary level of schools, bracket close, rules, 2016 has been relied upon. Stop. The petitioners failed to produce any rule which mentions that candidates possessing DLED qualification is to be given preference over B.Ed qualification. Stop. The score sheet of the petitioners are annexed to the writ petition. Stop. It appears that the petitioners have been given full marks on account of the professional score. Stop. Paragraph. Learned advocate representing the commission submits that the petitioners, being unsuccessful in the recruitment process, has approached this court to unsettle the settled position. Stop. Paragraph. Upon hearing the parties and on perusal of the materials placed before this court, it appears that the petitioners participated in the recruitment process, relying on the rules, 2016. Stop. The grievance raised by the petitioners was duly heard by the commission, and it was detected that the petitioners failed to secure the cutoff marks. Stop. The cause of action for filing the instant writ petition appears to have arisen in the year 2021. Stop. The instant writ petition has been filed in the year 2024. Stop. Paragraph. The court is not satisfied with the grounds made out by the petitioner for interfering in the instant writ petition. Stop. The writ petition fails and is accordingly dismissed.
Subject to lordship correction. After publishing of the panel, file the writ petition.
Yes, that is more so the reason for dismissal. Next.
Deficit court fee and the affidavit of service.
Deficit court fee and the affidavit of service taken on record.
And my junior is appearing online.
All right.
I am for the petition.
Or I am for this statement.
I am filing my exception. On election for the post of headmaster of a school, petitioner participated in the selection process. Petitioner is the whitelisted candidate. As per the calculation of marks, he secured 67. Last time panel candidate has been given appointment 69. Petitioner filed the writ petition, taking plea that the 3 marks which petitioner is entitled in terms of the graduation and post-graduation mark sheet, it has not been given. Because as per the schedule, mark schedule, he got more than 60% of marks in graduation and post-graduation. But given 2 mark sheets, petitioner double graduation, double MSc. They have taken the lesser mark sheet of Calcutta University. So therefore, they have calculated on the basis of that given 22 marks.
Why did you give 2 mark sheets? Will you get double marks?
Yes, I must be candid too. But it could have been given only mark sheet
The
highest one. And they can consider the highest one also. But out of I do not know why given, but it has been given. But on the basis of that, first round of litigation, my Justice Chattopadhyay was pleased to consider the case of the petitioner, directed the commission to take into consideration all of falsehood. In the representation made, taking the same submission that I am entitled at least 3 marks. Commission passed the order without any discussion about the grievance of the petitioner. Kindly see the order passed by the commission at page 100. It is starts from 100, but 103.
103 will be important complaint.
Yes, 103. Yes.
Regarding calculation of academic score.
But not in case of the petitioner at all. No reflection in the impugned order.
This is Ramesh Banerjee.
Yes, my client is Nasiruddin Khan. And in the exception, before this Hon'ble Court, they took the plea at the time of submission of consideration. I was called on. I did not raise this issue.
And second thing,
And was this issue not raised in the earlier writ petition?
yes, page 62 of my exception kindly sees. They have dealt with on the exception, kindly take my exception at page 62. Categorically, I have stated in paragraph 18 of this.
1 minute. Page 103.
My lord.
This consideration was made in terms of the court's order.
My lord.
And you were a party over there.
Yes, petitioner number 15
Number 15.
of that petition.
So all the petitioners were heard
Yes, together.
together.
Yes.
This is the common order passed.
Common order passed.
Are 15 petitioners' case mentioned in this order?
Yes.
It is.
In my case, nothing reflection, but in other petitioners, but they have made certain observation. I have filed a separate petition, this pending.
Oh, that is different.
That is
But
true.
then
But in respect of the petitioner,
Nasiruddin
nothing has been reflected. But since that is there, my lord Justice Bhattacharya was pleased to accept the petition, directing to file the exception.
Yes,
That
the exception
in the
is-
exception paragraph 7 to 12 kindly sees.
they say that this point has not been
Not
raised.
been raised. If was raised, it could have been. But kindly come to my lord page 62 of the exception itself. In the earlier round of litigation, in that exception, categorical statement has been made. Paragraph 26. Can see calculation given. Petitioner number 15 has been awarded in that fashion. In graduation 4, I am entitled 6 because I got the 60% of marks in terms of that schedule. And in my post graduation, it has been given 5. I am entitled to 6.
Yes.
So I am 70, and last time panel candidate given 69.
Alright, let me hear. This point was not raised?
No, they were called in groups, possibly groups of 5, and they were given hearing. The case of the petitioner is identical to the case of Ramesh Banerjee. Ramesh Banerjee raised the issues, so with his name it has been dealt with. The other candidate, the petitioner before the court now, was silent during the, but the issues are absolutely identical.
I do not know. See, 103, issue number 4.
Yes,
Complaint against calculation of academic score by one petitioner,
yes,
and one petitioner, Ramesh Banerjee.
yes,
Is Nasiruddin also considered here?
yes, but no, it is not mentioned because he did not specifically say that I have this grievance, etc., etc. He came, he listened, he allowed the proceedings to go on and he left. I'm not going into that because that is neither here or there. I cannot prove, he cannot prove. Let us not go into that. But the fact remains the case is identical.
Alright, sure.
Now what my learned friend has submitted that I applied with 2 postgraduates, he did not. He could not. The system will not allow it. He applied with the degree which he had, which was an MSc in pure science, in mathematics possibly. Kindly see our report, page 8, the online application of the petitioner. We cannot go beyond the documents he has participated with.
Yes.
Our report, my lord has got it, page 8. We have annexed the online application of Nasiruddin.
Alright.
Kindly see the box in the middle of the page.
Yes.
The last line, sorry, the second last line.
Marks in
Marks at postgraduate level,
Yes.
560 out of 1000, below 60 to 50. This was his mark sheet which he had submitted. That was the one having the lower marks. That is the subject on which he teaches. That is the subject in which he has the BSc also. Now kindly see the very next page. This is a much later stage during document verification. This was 2016 online application. 2018. This gentleman has come the second column. He has signed and put his date. The other one does not apply. 4, 5. Name of university mentioned here.
Chhatrapati
Yes,
Shivaji.
it was put in there. And to that he has put his signature. So this is the mark sheet on which he proceeded.
Which is below 60.
Yes.
50 to 60.
Yes. Now he has come up with one
mark sheet from Netaji Subhash Open University, which is an open university. We are not disqualifying on that ground, but anybody at any time can participate. It is so broad. The rules are so broad that a candidate can appear at any point. Now he has come with this mark sheet showing that I have above higher marks. The intention is not the academic score. The intention is that I have to get above 50% marks to come in the zone of consideration.
Above 50 or 60?
No, 50. To be a headmaster, one is to have 10 years teaching experience and 50% marks in the master degree level.
Yes.
So that I think he had. Let me just.
Yes, he
had.
this.
Yes, 560 out of 1000. But the second mark sheet, he has never produced before us, not even in 2018 at the time of verification. This is my submission. This is my
Subject to correction, all this point was taken in the earlier round of litigation.
No, but then how can you come out of pages 8 and 9?
The documents on the online, but on the date of verification. I have stated in paragraph 26.
Your statement will not do. You have made online application. You have disclosed your own score.
Yes.
You have participated in the hearing, document verification. Your documents are there. You signed it. Why will the court disbelieve?
This is the 5. I dealt with in paragraph 10 of my exception.
Yes.
What have you 10 exception?
What have you stated?
I have stated that on the date when I participated with all these documents, now they only directed me to sign only 5 seconds without verifying all these documents. It is knows this. 5 seconds I put my signature. I cannot deny this signature. But on the very next day, when I produce all these documents, the commission's authority said put it. But I could not.
But then this is your paper.
That is, but then, I kindly cease.
No, sorry.
I'm kindly cease. One minute. But they are saying it is the documents I just produced, but with all the documents of both the mark sheets.
Both the mark sheets will not do. One, you have applied in the application form. You have to show that. You did not rely upon the Netaji Subhash marks.
No,
you relied upon Chhatrapati Shivaji's marks. What can be done?
This is the documents. And if your lordship kindly take after the order passed by the court, kindly see the order passed by the court.
First, don't go to the order. What is your application? Page 8. You have mentioned between 650 and 60. You have not mentioned above 60.
In the application.
In the application. Then?
But on the date of verification.
No. Please come. The petitioner is aggrieved by the awarding of marks in the recruitment process of headmaster conducted by the West Bengal Central Service Commission, Central School Service Commission. Submission of the petitioner is that he possesses 2 postgraduate degree certificate, one with marks below 60% and the other with marks above 60%. Stop.
Both graduation and post graduation both.
আচ্ছা, in graduation যেখানে বললেন post graduate, সেখানে in graduation and post graduation. ঠিক আছে? Submission of the petitioner is that the commission considered the post graduation marks of the petitioner by referring to the certificate with lower marks, ignoring the certificate with higher marks. Stop. It has been contended that if the certificate with more marks is taken into consideration, then the petitioner would be entitled to 3 more marks, which will take him to the cutoff marks. Stop. Paragraph. Learned. Now, the commission has filed an affidavit enclosing the online application form filed by the petitioner. Stop. The application form clearly mentions that the marks obtained by him in the post-graduation level is between 50% to 60%. Stop. The petitioner was called for A verification of testimonials when the petitioner attended and put his signature in the attendance sheet. Stop. The marks secured by the petitioner in the post-graduation level also mentions that he secured marks less than 60%. Stop. The university from where the petitioner acquired the post checklist, which has been checklist for verification of testimonials, which has been annexed to the opposition filed by the commission. Stop paragraph. Learned advocate for the commission submits that had the petitioner produced the certificate with more marks at the time of credential verification and had mentioned about the said certificate at the time of filing of the application, comma, then the same could have been considered by the commission. Stop. It is the specific submission that there is no scope for considering two certificates. Stop. The petitioner ought to have relied on the certificate with more marks. Paragraph. Upon hearing the submission made on behalf of both the parties, it appears that even though the petitioner claims to possess two post-graduation certificates, comma, for reasons best known, comma, he mentioned about the certificate with lesser marks in the application form and also produced the same certificate at the time of credential verification. Stop. The petitioner did not disclose the certificate with higher marks in the selection process. Stop. Paragraph. The certificate which the petitioner has relied upon mentions that he secured marks less than 60%. Stop. The commission has awarded marks taking into consideration the said score of the petitioner in the post-graduation level. Stop. Next. The submission of the petitioner that the certificate with higher marks is to be taken into consideration cannot be accepted as the petitioner himself failed to disclose the said marks at the time of filing the application form. Stop. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Ekdam upore, exception by the petitioner to the affidavit filed by the commission be retained with the records.
The exception filed by me. Yes.
I am for the state.
I'm for the petitioner, my lord. My lord, regarding higher scale of pay, the issue has been settled by Utpal Kanti Karan. My lord, kindly come to the impugned order at page 56. Page 56. I joined to the master's degree course. After that, my lord, I joined in the service. So, my lord, there was no scope for prior permission. And latest, my lord, your lordship passed this order. In the latest, my lord, lastly, your lordship passed this order by setting aside the order and sending this.
593 has been referred.
593 possibly not.
Geo is referred over here.
Yes, it is not there possibly.
Ah.
But your lordship, that was 1595. This is 593.
This is 593. Bring 593 also order has been passed.
That I am not have, my lord.
Check up. Come, check up and come.
Kindly set aside, my lord. Kindly set aside, my lord. This can and send it to the DI. Your lordship has sent it to the DI.
Yes, send it to the DI, but then 593 is specifically mentioned over here.
I got the notification. It has been referred in Utpal Kanti Karan. Kindly see. I'm facing Utpal Kanti Karan.
Please show.
Yes. 593 regarding G. Kindly take, my lord, G. G is regarding with when the candidate initiates the process, and I'm showing, I'm sorry, I have only one copy.
That doesn't matter, I have copy.
So it refers to 1595. I'm showing the respective paragraph. This is only guideline which shows in regard when the candidate initiated previously, but in refer the author court directed to follow 1595.
593 has also been set aside.
Yes, I'm showing.
Specifically,
I'm showing. Referring
you were showing 1595.
I'm submitting. This is the paragraph which says.
I understand the paragraph may be the same, but the geo number, this particular geo has been set aside.
Yes, I'm submitting. Here it has been stated only one paragraph which says when you have initiated previously and joined subsequently, then 1595 has to be followed. This paragraph and covered under this paragraph. Now I'm showing my lord 593. 593 referring to Adiluzzaman, my lord, it has been, I'm showing paragraph. Sorry, my lord, I just. দেখাচ্ছি my lord, will it be suffice if I show the Adiluzzaman observation? I have marked, my lord, Adiluzzaman. I'm squarely covered under Adiluzzaman also.
You are going this case.
Yes, I'm showing. This is 593. Kindly see.
27 November 2007. Right.
That
We
has
consider the we consider the government order dated. Yes, 27 November.
That has been dealt with in Adiluzzaman, accepted in Uttarakanti Goro.
Aj, please come. The petitioner seeks higher scale of pay. Acha. His prayer has been rejected by the District Inspector of Schools, Secondary Education, Bird 1. Wide communicating memo dated 13th May 2016 with the observation that.
May I just say one thing? My lord, when petitioner started the course, then this memo did not come. So it has got no retrospective effect as well.
Tell me, 2016 you were challenging in 24. The impugned order, page 56, is of 2016.
Yes, my lord, it's a continuing claim, my lord. Kindly.
Why so delayed? Point of time you approach the court.
Yes, my lord, I cannot develop it. My lord, I candidly submit.
Nothing.
No, my lord. That's just an impugned order. Because my lord, I've come after Utpal Kanti Forum, your lordship. My lord. And my lord, no retrospective effect can be given to this.
Achha. Now ওইটাতেই এইটা কনসিডার করা হয়েছে।
And one more thing, my lord, when he got the admission, then 593 notification did not come into effect.
When the candidate got the admission?
2007 beginning. It came 2007 end, November. It does not.
Where is it?
Yes, I'm showing, my lord. My lord, kindly take the page 46, his hostel admissions receipt of 12th of October 2007, and his admission at page 45 also.
Is it August, page 46?
This is, my lord, 12th of October, possibly.
10.
10.
All right.
That is of November. And previous page also, your lordship will find 17th of August 2007, he deposited his fees for master's degree course.
All right.
So it is does not have even retrospective effect.
With the observation that the petitioner failed to obtain the prior permission of the DI. Vide geo number 593-caps SE within bracket B, dated 27th of November 2007. Stop paragraph. Learned advocate for the petitioner submits that the day when the petitioner took admission in the post-graduation course, comma, the subject GO dated 27th November 2007 was not in existence. Stop. The said GO does not have any retrospective effect, and accordingly, the said government order cannot be made applicable in case of the petitioner. Stop. It has also been submitted that the issue as to whether the candidate who did not obtain prior permission in terms of GO number 593-SE within bracket B dated 27th of November 2007 will get the benefit of higher scale of pay has been conclusively decided by the larger bench of this court in the matter of Utpal Kanti Karan. Full cost title.
Citation is given at the top, my lord. 2040 yes.
Yes. The prayer has been made to set aside the impugned memo and to direct the authority to grant higher scale of pay to the petitioner.
Along with arrear also.
Along with arrears. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that the referred government order dated 27th of November 2007 has been set aside by the Honorable Division Bench of this court on 11th February 2021 in Mat 825 of 2020 in the matter of Adiluz Zaman ADWL AJ Uz Zaman versus State of West Bengal and others. Issue raised by the petitioner has been dealt with in the matter of Utpal Kanti Karan. Stop. Next. The subject memo dated 27th November 2007 did not have any existence on the day the petitioner got admitted in the post-graduation course, and accordingly the said memo cannot be applied retrospectively in case of the petitioner. Stop. Next. In view of the above, the impugned order dated 13th May 2016 stands set aside. Stop. The prayer of the petitioner for grant of higher scale of pay is directed to be reconsidered by the District Inspector of Schools, Secondary Education, Burdwan, in the light of the judgment delivered in the matter of Utpal Kanti Karan at the earliest, but positively within a period of 12 weeks from the date of communication of this order. The authority shall consider the prayer of the petitioner for grant of arrear pay.
Arrear interest also, my lord.
No. The prayer of the petitioner for grant of interest.
Kindly do not, my lord, observe.
No.
Kindly do not observe.
Otherwise, you'll come up.
No, I will be barred by res judicata. I will be barred by res judicata. Anyways, I will be barred by res judicata.
Prayer of the petitioner
But it will have impact on subsequent matters. My lord, kindly do not.
on account of
No, kindly do not.
the delayed payment of the higher scale of pay cannot be allowed by the court, particularly because of the reason that the petitioner
My lord, kindly
challenges the impugned order passed on 13th May 2016 by filing the writ petition in the year 2024.
that will have an impact in my main issue. Kindly do not observe
Stop.
that.
It will not impact. You will get in future.
Utpal Kanti Karan came subsequently.
Next.
That is why I have come.
The The if the district inspector of schools opines in favor of the petitioner, comma, then necessary consequential relief shall be provided to the petitioner without any further delay. Disposed.
It will be Bureau 1, DI of Purbo Bardhaman.
আচ্ছা পূর্ব বর্ধমান
Respondent number 4.
Respond number 3. 3.
3
May I take back the Utpal Kanti College?
কলকে ফেরত দিয়ে দিন
Yes.
এটাকেও ফেরত দিয়ে দিন
Let that be in the
এটা দরকার নেই সার্ভিস ইজ টেকেন অন রেকর্ড
grateful to your lordship, much obliged.
এটাও দরকার নেই এটা ফেরত দিয়ে দিন
I'm for the petition.
and for secondary board your lordship
My lord, I had made combined writ petition with combined prayers. My lord, presently the petition, initially what happened, petitioner was not allowed to enter the school by dint of the previous order of the Honorable Court. She has been allowed to enter. Eventually she had got retired. I have only 2 prayers left today to place before lordship regarding the pensionary benefits because she has by now retired. Now, my lord, in the order, what happened? Kindly come to the previous order of the Honorable Court at page 41. I'm sorry, page 41.
enough yes
May I place it before lordship? Pursuant to the order dated 6 September
what
2020.
is the operative portion there?
Operative portion is that, my lord, kindly come to page 42, second paragraph. Having considered the submission made on behalf of the parties, this court permits the learned advocate representing the board to hand over show cause notice dated 8th of May 2023 to the learned advocate representing the petitioner, which would be treated as service of show cause notice upon the petitioner. Petitioner is directed to offer reply to the show cause notice by Friday next 4th October 2024 without praying for extension of time for submitting reply till consideration of reply to said show cause notice of charge sheet dated 10th September 2024 shall be kept in abeyance. The concerned authority of the board shall consider the reply to the show cause notice, and if finds that there is requirement to initiate disciplinary proceedings, then an appropriate order shall be passed for reviving the charge sheet dated 10th September 2024. Otherwise, the proceeding shall be dropped. Now, my lord, what happened initially, show cause notice was issued, it was not served upon me. Without my reply, charge sheet was issued. That was challenged in this writ petition. Now, the Honorable Court was kind enough to allow me to give response to the show cause. I gave response, that is at page 55. I gave the response on within time.
Was the charge sheet revived?
Yes. Now, my lord, that has not been
direct no
that has not been served upon me. I do not know whether there is any disciplinary proceeding today. My post-retirement benefit has not yet been.
Well, it has been served your lordship. This is the court directed me to file a report my lord. This is the report
May I get a copy of?
হ্যাঁ নিশ্চয়ই কোনো পাবি না বাবা এটাতে অ্যানেক্সারটা করা আছে নাকি দেখি কি হচ্ছে কি
No, this is the charge sheet.
January 2025
This charge sheet is the
no this is the
writ petition.
no this charge sheet has been the revised charge sheet. This one my lord I have explained in my report. Well, main writ petition, my lord, main writ petition, my lord, the writ petition charge sheet could not have been annexed because this is dated 6th of January. Maybe the contents is the same. See, the court's order is of 27th of September 24.
Yes.
And the charge sheet is January 25. So definitely it is after your response to the
Possible. May I come back after
so-
seeing? I need to see and take instruction. My lord.
all right.
I need to come back.
Report filed by the West Bengal Board of Secondary Education. In court today be retained with the records. Stop. Submission of the board is that that on receipt of the response to the show cause, comma, the board revived the charge sheet issued against the petitioner, and a fresh charge sheet was issued on 6th January 2025, which is annexed to the report. Stop. The board has taken a decision to initiate disciplinary proceeding against the petitioner. Stop. Copy of the report has been handed over to the petitioner to the learned advocate for the petitioner in court today. Stop. Prayer has been made to permit the petitioner to revert with an exception. Stop. Let exception be prepared and circulated by 2 weeks will be all right with you?
3 weeks.
6th of March.
Take instruction, all sorts of.
All right. 6th of March. Released on 20th of March 20.
Great. But in the meantime, provisional pension may be allowed. I am entitled to provisional pension.
As the petitioner has superannuated from service on
January 2025.
in the month of January 2025, the admissible terminal dues of the petitioner shall be processed
20th.
and paid
If not already. I don't know school
in
has.
accordance with law.
My lord, here, my lord, the school has to say something.
File your report.
The issue is that we have sent letters to the petitioner asking for OTPs with regard to her e-pension papers.
Nothing, she is not
OTP has
cooperating.
been provided.
I don't know.
He was absent for nearly 2 years. And that is the whole crux of the charge sheet.
Yes.
That is the previous.
Very good. I'll
It will be open for school
to file a report.
to file a report by way of
I represent
affidavit.
the headmistress, my lord. The managing committee is represented by Mr. Roy.
Headmistress of the school. School बोला the headmistress of the school. 28th March. By 20. Will 2 weeks be all right with you? 20.
Same, my lord.
Acha. Then he has to file an exception again.
2 weeks.
I'll do one thing. 2nd of March করুন ঠিক আছে আর বাদ দিন 6th of March করে দিন and 20th March it is already returnable. It will be open for the petitioner to file exception to the report prior to the adjourned date. 20.
Obliged to launch.
একসাথেই করে দিতে পারেন হ্যাঁ পরে ওটা না ওর মামলাটা পরেরটা লিখুন
Timetable number 20 minute time for the petitioner. Petitioner is the assistant teacher in a government aided school, my lord. Petitioner is not receiving my lord HRA amount. The ground is my lord husband of the petitioner is working in a private sector. My lord, what happened, my lord? Kindly see the pay slip of the petitioner is in annex page 18. My lord, kindly see HRA amount is 0. My lord, it is the July 2024 slip, my lord. So my lord, this issue is dealt by the honorable.
No, has it been refused in any ground?
No, it is pending for consideration, my lord. It has stopped. Now it is stopped, admitted position, it has stopped, page 18, my lord.
Did you ever receive it?
Yes.
Show that.
That previously, my lord, that I have stated, my lord, from July 2024, it has stopped. That slip.
Previous there too you received?
Yes. There is no,
And there is no reason also mentioned?
No.
Because your husband is receiving
No.
nothing.
But July 2020, July
Suddenly stopped.
My lord. This issue has dealt by the honorable coordinate bench. Kindly see, my lord, they relied the DI relied some GO which has been struck down by the honorable court, but order passed by the Justice Sarah. Similar issue, my lord, private sector employee spouse is working as private
appeal
sector.
has been preferred, but unfortunately that has been not been proceeded with and dismissed. You will be proceeding with the appeal, and by this time, my lord, the state is not creating any embargo during the HRA. Grateful.
The petitioner alleges that her house rent allowance has suddenly been stopped from July 2024 without disclosing any reason. Stop. Submission of the petitioner is that her husband works in a private organization. Stop. Next. The issue as to whether the teacher would be entitled to receive house rent allowance if the spouse works in a private organization has been conclusively dealt with by the court in the matter of
It is Moshumi, my lord. It has referred Moshumi Bishas, my lord. It has WPA 1389, page 2, my lord. WPA 1389 of 2028. A batch of matter has come up.
Yes.
Justice Sarah has been dealt with.
by judgment dated 16th March 2021 in WPA dated such and such in a batch of writ petitions. First of which is WPA 1389 of 2018. Moushumi Biswas and others versus State of West Bengal and others. Date of dismissal of the appeal, are you aware?
Just recently, 1 or 2 months before.
আমাদের ইয়ে রয়েছে ডেটা এন্ট্রি অপারেটর আছে MAT 1023 of 2021, check the order please. The appeal preferred against the aforesaid judgment. In MAT 1023 of 2021, within brackets, State of West Bengal and others versus Mita Mojumdar and others, stood dismissed.
For default only.
এত বড় order for default? দেখি নিচটা চলুন দেখি এসে disposed of can এত in mat এত stands disposed of আরেকটু উপর দিকে চলুন all IA then আরেকটু উপরে mat with such and such stands check up from your phone. এটা ডেট কত দেখুন তো 1023 of 2021. Is it 4th of December 2025? 4th December 2025. ওটা FMA নম্বর পড়ে গেছে FMA 654 of 2022. 2023. ঠিক আছে? Stop. Paragraph. As it appears that the issue has conclusively been decided by the court, accordingly, the authority cannot withhold the house rent allowance.
Appeal is only for default.
Allowance payable to the teacher. Stop. Next. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Hooghly, to
current and ADR both.
To disburse the current as well as arrear house rent allowance payable to the petitioner in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Disposed. এটা থাকুক যদি আপনার ইন কেস দরকার লাগে সার্ভিস টেকেন অন রেকর্ড
time for the petitioner.
Although there was a direction for exchange of affidavits, day before yesterday, I have received only for this reason. But if you see, only paragraph 8.
Let me place my.
All right, yes.
This is a third round of litigation, my lord. Initially, my lord, this petitioner applied for being appointed as a teacher in the 12th regional level selection test. My lord, petitioner was a para teacher and there was a in-service quota.
2 years shortfall?
Yes, my lord. Why 2 years? I tell your lordship. My lord, I filed the first round of litigation claiming appointment that I have not been, in spite of securing higher marks. My lord, that matter was taken up by this honorable court. This honorable court, my lord, page 25 specifically here, because of the negligency and wrongful attitude of the commission, this petitioner could not be appointed in time and ultimately directed the petitioner to be appointed. That was in 2015, petitioner was ultimately appointed. And my lord, all other similarly situated persons were appointed in November. My lord, 2013 November. My lord, thereafter, my lord, I retired from service on 31st of May 2023. I filed this writ petition, my lord, saying that this should be condoned. It was not my fault. My lord, this honorable court sent the matter to the authorities for consideration. They have rejected my prayer, my lord, on the ground that 2 years cannot be condoned. My case is, my lord, there is a division bench judgment in support, my lord, that if the wrong is attributable to the respondent, petitioner cannot be made to suffer. And in that very scope, that was also a pension case. My lord, petitioner, now my lord, if my appointment is being considered for November 2013, my service would be 9 years, 6 months. And my lord, 6 months is condonable. There too, there is a judgment of the coordinate bench that up to 6 months it can be condonable.
But the rules also say so.
Rules
Also says so.
7E4 DCRB say up to 6 months we can, but here the period is more than 2 years.
If my
Therefore, that on that ground, it has been rejected.
2013. If my service is, kindly come to page 25 once.
Yes, 25 I can see.
I am basing the order, my lord, in course of second paragraph. In course of initial hearing, it was contended on behalf of the regional commission that the petitioner by dint of his performance did not qualify for being included in the combined merit list. Therefore, there is no informity in the action of the regional commission. Hearing such submission, this bench had called for affidavits. Since affidavit was not filed, prayer for extension was made. Such prayer was allowed. Condonation of payment of cost, my lord. It was at this stage that Mr. Swanso, learned advocate for the regional commission, admitted to an inadvertence being the cause for not including the petitioner in the combined merit list. It has also been submitted by Swanso that having regard to the marks obtained by the petitioner, he was entitled to issuance of a recommendation letter in his favor. The fact that have now surfaced after this bench called upon the regional commission to put on record its version or indeed.
When were the candidates in respect of this selection process given appointment?
November 2013.
November 2013. Where from do you get that?
Yes, my lord. November. Here, my lord, I can say similar matters, my lord, where candidates were appointed in 2023. My lord, notional matters relating to notional benefit was filed. There the principal secretary have this order, has given notional benefit in respect of 12th LST from November 2013. Your lordship also has passed such orders.
Yes.
So my lord, it is evident. The records would also show, my lord, the appointments were given from November 2013.
All right, yes.
Sir, my only submission, if you see paragraph 8.
There is no provision.
There is no
But what about the order?
But the order
specific
this is for that reason, my lord, the matter was sent back before the principal secretary. Now, my lord, the order of the principal secretary is under challenge before your lordship.
Yes.
If your lordship see once, my lord, the order of the principal secretary, my lord, it will appear, my lord, page 46.
Yes, yes.
My lord, if your lordship see paragraph 4. This is my, I cannot improve, my lord. This
right,
is
please come. Sadeep, please stop that phone. The petitioner challenges the order dated 4th October 2024 passed by the Principal Secretary School Education Department rejecting the prayer of the petitioner for condoning shortfall of the qualifying service period for receiving pension for 2 years. Paragraph. The impugned order records that shortfall of 6 months is condonable under DCRB scheme, 1981. Learned advocate for the petitioner submits that the petitioner was provided appointment when in
page
May 28. May 2015.
Yes.
In May 2018.
2015.
2015. May 2015. Though appointment in respect of the other selected candidates in 12th RLST was given in November 2013. Stop. Submission is that had the petitioner been given appointment in November 2013, then he could he would have been eligible to receive pension under DCRB scheme. Stop. Paragraph. Reference has been made to the order dated 23rd March 2015 passed in the writ petition filed by the petitioner being WP 30828 W of 2014
to 4. 30824.
30824 30824 W of 2014, wherein specific submission of the regional commission has been recorded that there was an inadvertence on the part of the commission in not including the petitioner in the combined merit list. Stop. Specific submission of the commission was that the petitioner was entitled to issuance of a recommendation letter in his favor. The court observed that a candidate, despite being entitled to a recommendation, was being deprived of the same without any fault on his part. Stop. Relying on the aforesaid observation of the court, the petitioner contends that he ought to be given notional benefit from the date when other candidates of the same RLST were provided appointment. Stop. Paragraph. Did you bring the division benches order?
Yes, ma'am.
Please show.
Paragraph 8.
Learned advocate for the petitioner relies on the order passed by the Honorable Division Bench of this court on 16th of August 2023 in FMA 687 of 22 with Namtali Genevan, wherein the court clearly recorded that
Paragraph 12.
A litigant cannot be made to suffer for the delay caused in processing his application for appointment. Next. A learned advocate representing the state respondents submits that there is no provision in the DCRB scheme for condoning the shortfall beyond a period of 6 months. Upon hearing the submission made on behalf of both the parties and on perusal of the documents annexed to the writ petition, it is evident that the delay in issuing the appointment letter in favor of the petitioner was no way attributable to the petitioner. Had the petitioner been issued the letter of appointment in proper time, then in November 2013, he would have joined service. The petitioner would have been only 6 months short for receiving his pension had he been issued the letter of appointment in November 2013. the balance 6 months period, the balance 6 months period, you know, not balance, the shortfall in the 6 months period is controllable under the DCRB scheme. Stop. Next. The Honorable Division Bench in the matter of Basudev Purkait, clear within brackets Supra, laid down that the litigant cannot be made to suffer for no fault on his part. Stuff. Next. In view of the above, the impugned rejection of the Principal Secretary stands set aside. Stop. The District Inspector of Schools Secondary Education Purva Bardhaman is directed to grant notional benefit to the petitioner on and from November 2013, the date on which the other candidates in RLST 12 were given appointment. Stop. The notional benefit will be restricted only for the purpose of calculating the pensionary dues of the petitioner. Stop. The provision of section provision of clause 7 within bracket small e within bracket small iv 4 of DCRB scheme 1981 shall also be taken into consideration by the authority. Stop. It is made abundantly clear that the petitioner would not be entitled to claim any salary for the period the petitioner did not actually provide his service. Stop. Paragraph. The District Inspector of Schools shall make the necessary calculation and take all steps to ensure that the benefit under the DCRB scheme is disbursed in favor of the petitioner at the earliest, but positively within a period of 6 months from the date of communication of this order. 8 petition stands disposed. Impugned order set aside bollam to. Principal Secretary, School Education Department, page 51.
Lord, I have retired on 31st of May 2023. From that period, arrears may otherwise.
The arrears of pension from the day the petitioner retired from service on superannuation shall also be disbursed.
Secondary body.
Praying for recognition of the school. Lord,
Who are you?
we are the secretary of the managing committee as well as the teaching and non-teaching staffs of the school. This is our 6th round of litigation. The coordinated bench passed an order directing us to cure the deficiency, infrastructure deficiencies, which was reported before the court by the state authorities that these deficiencies were there. Liberty was given to us to cure that, and we cured it.
Where is it?
Kindly see the last order, page 97. Order dated 12th September 2023.
Show me that you cured the defects that were pointed out.
Yes, madam.
9/2020.
Kindly see the defects first, madam. The report was filed by the state authority. Those are the defects. Now, madam, after curing this, madam, they have come up with rejected, saying that other defects are there. But one after another, madam, other grounds are being shown. Well, kindly comes page 103, which was the report submitted by before the coordinated bench. This is the inquiry report, deficiency.
Yes.
Kindly see page 104.
Yes, whether the school has a
Whether the
building.
school has a building, in all weather and sanctioned building plan. In WP number so and so, they have annexed a building plan in so and so. At present, they have a building unable.
Usable.
Usable. In all weather with 4 classrooms and the staff room. The classroom are well
Equipped with blackboards and chair and
blackboard
tables.
Whether the school has a,
Yes, there are several defects I see.
yes.
Then,
Now, my lord, these defects were cured and the school authority
the deficiency still exists which needs to be cured, page 106.
page 106.
This is in April 2024.
April 2024.
Thereafter,
Thereafter, my lord, the (125) kindly see, my lord, the impugned order. Page
No
103,
playgrounds.
the earlier report
ah,
says that some of the defects that was cured.
alright, there are other defects also. No playground for the students, no library, teachers are not eligible for NCT. Yes, 21-26.
Yes,
Hence,
page
no
105,
objection.
earlier report.
Cannot be recommended.
Playground was there, it was their report, page 105. And you see earlier report says playground is there, now they are saying playground is not there. 105. 105, this is the earlier report.
Where is that there is a playground?
Serial number 3. Whether the school has a middle portion. School has a playground for students, they have area.
Whether there is whether the school has playground. Where is the finding that the school has a playground?
And you see, they have a area which may be used for playgrounds
If it is
developed adequately.
then, so there is no finding that there is a playground.
The area is there, my lord.
You make a construction over there.
open.
No. The specific finding is that there is a playground.
The next round of rejection is that there is no library.
Yes.
Kindly see next point.
No, listen, the court will not go into all these things. You cure the deficiencies and they will
That
look
is
into it.
precisely the order. 139, your lordship, can you?
139.
This is the content application they have taken out, and what is the finding of the? Kindly take 139.
May I submit one thing? Let them file a report specific deficiencies which we have.
Sorry.
Specific deficiencies, my lord.
Specific
Fire safety.
is mentioned over here.
Fire safety. We have submitted the fire safety NOC.
Kindly see 139, what is that scope, Lord? 139. This is the contempt application they have taken out with us. The contempt application is dismissed with certain observations. Kindly see, Lord, 139.
Accordingly,
Has your lordship got it? The sentence starts accordingly.
in the middle.
Accordingly, this contempt proceeding such as stands dropped and closed. However, dismissal of this contempt proceeding shall not preclude the school authority to cure the deficiency.
The school is always open to cure deficiencies.
The fullest satisfaction of the state authority.
Right.
In every respect.
Sorry.
In accordance with law.
The petitioners pray for recognition of a junior high school.
Only see the photographs are annexed. Library, photograph of the library.
The photographs I see, they are not fit for being used as school. Sorry, I'm not satisfied. কি বলে? Stop. From the documents annexed to the writ petition, it appears that the school, the alleged school was physically examined and certain infirmities / deficiencies have been found, for which recognition has not been allowed. Stop. Paragraph. It will be open for the
Another finding is there.
to cure the deficiencies and infirmities for obtaining recognition of this school.
But another 131 will have to.
Very important, very important.
Kindly sees the views. 131. And
Yes.
consider this aspect also, but it is very important.
Yes.
The location where the school is situated is a municipality under such and such municipality. At present, there are 10 number of government sponsored schools currently running. Not only that, in this municipality, there are sufficient private schools at present. So it appears that if the school will get recognition, then the school will face a problem to catch students for admission, as because there is sufficient number of schools under that municipality.
This issue has been settled by this honorable court in earlier round of litigation by Justice Indira Banerjee.
The student shortage to run the school, which is in question in nearly future.
The number of schools will not debar the authority to give recognition. But that was decided.
That is the reason I am getting matters where the teachers are being paid their salary without a single student being there for years together.
Yes.
Yes.
The government will certainly take steps.
Kindly consider this aspect also.
The observation of the District Inspector of Schools, Secondary Education, Dokhin Dinajpur. Dated 5th of July 2024. As regards location of the school shall also be taken care of at the time of granting recognition, if any. Writ petition disposed.
Dismiss the.
My lord, I am appearing on behalf of the petitioner.
At the outset, I indicate to your lordship that there is a default on my part.
Where?
In this
So there is
matter.
a direction of filing.
If I am affidavit, kindly permit us to
Who are you
return
representing?
the school authorities.
All right.
Here at
It's a grievance.
grievance is my lord, petitioner service was terminated by the notice of the advocate. Advocate on record of the school. Is a peculiar situation, my lord. Coordinate bench has directed response this, my lord. Kindly see the order.
The notice, please.
In the supplementary affidavit. 14th, have you lordship got it? Supplementary affidavit, 1 annexure, P12. Termination of your employment from Gyan
1 minute. Supplementary affidavit.
My lord, 1 annexure, my lord. Kindly say page annexure P12. 14 July 2025. Termination of your employment from Gyan Bharati Vidyapit. Who has issued it? My lord, Nikon
Nikunj earlier,
Hmm.
advocate on record of the petitioner. This is the big of the school authority.
Hmm.
How he has the authority to terminate my service? He is not my employer. Well, the background of the case is the petitioner has challenged.
Do I come with an affidavit?
How come this document of the learned advocate is there in the supplementary and not in the main writ petition?
Well, during the pendency of the writ petition, he has issued the same.
All right.
But here the
And
petitioner has-
one minute. What is the challenge in the writ petition?
Writ petition challenges, my lord, the validity of the inquiry because defunct managing committee has no authority to initiate the disciplinary proceeding. I am armed with the division bench judgment. Division bench has specifically held that defunct managing committee has no authority to initiate any kind of proceedings. When the matter is pending, what is the session of the matter? Well, they have issued the termination letter and communicated by the advocate. And while armed with the division bench judgment, while the division bench presided over by Justice Dipankar Dattamal.
Assuming this learned advocate's letter is set aside,
Yes.
even then your challenge to the writ petition remains.
Yes, remains.
Right?
So for that- And so for the my lord, after termination, my subsistence allowance also to stop, my lord.
All right. Since when?
July.
July, my lord.
When were you suspended?
Suspension is like April 2024.
April 24.
And stop from, my lord, after termination.
All right. Prior thereto, you got the suspension allowance. Yes, please.
Kindly permit me to come with an affidavit.
Pay the subsistence allowance.
Yes.
This cannot be permitted to stand. The supplementary affidavit communication by the learned advocate cannot be permitted to stand. The writ petition's challenge remains.
No, the then not your lordship will have to hear the main matter. Kindly, the issue here is
Support this.
the issue is
Issue the court will consider. You file your report. Whether you have got a managing committee, you don't have, whatever.
when I am a private unaided school, I am not even amenable to the extraordinary high prerogative
All
at the
right.
instance of an employee.
All right. That the court will decide.
Yes.
But this
This is on instructions from the school. The school has instructed the advocate.
cannot be done.
The school is going to communicate. Tomorrow,
Just let him communicate.
the school is going to do it tomorrow.
This
Well,
cannot
instead-
be permitted to stand. It is this.
Thereafter,
Thereafter,
kindly do not pass this order today.
no. Acha. The
Kindly do not, kindly allow us
by
to.
the school.
Yes,
The steps taken by the school.
The question of maintainability is open.
I'll keep it open. That will remain open. By the school in initiating disciplinary proceeding against the petitioner is impugned in the instant writ petition. Stop. The petitioner has been suspended from service in April 2025.
2024.
At the 2024, and the writ petition has been filed
On 11 February 2025. February 2025. 6th
on
February.
11th of
6th
February
February. 6th.
2025. Yes, sir. During pendency of the instant writ petition, by a communicating letter dated 14th of July 2025, by the learned advocate of the school, the service of the petitioner has been terminated. Stop. Supplementary affidavit has been filed challenging such subsequent cause of action of termination of the petitioner. It appears that direction has been passed for filing affidavit in the matter. Affidavit or a report, what?
No, affidavit.
Affidavit in the matter.
Kindly extend the time, we'll respond.
Last December 2025, my lord.
1st of December 2020, on 1st of December 2025, সব পাতা ছিঁড়ে বেরিয়েছে বেড়াচ্ছে। On 1st of December 2025, কোথায় সে অর্ডারটা কোথায়? এখানে দেখতে পাচ্ছি Honorable Court's order dated 1st December. But where is that order? এইটা। 1st December. The school is directed to file a response to the supplementary. There was a direction
Yes,
to
yes, but
file a
I-
response to the, I have a copy. To file a response to the supplementary, possibly there is no direction to file affidavit
Court has
petition.
informed His Lordship, at first, this issue will be decided, then, so for the main matter.
Because the maintainability is seriously in question.
Yes.
Because it's a private unaided school and he is not governed by anything. One of the petitions at the school's instance is also pending consideration and it is coming out.
Is an
And on maintainability point, Malad, I have some submissions to make.
Yes, yes.
The writ petition is very much maintainable, Malad.
Yes,
Why I
yes, yes,
submitted
the
that?
court will hear you.
Yes, yes.
আচ্ছা, কি বললাম? না, affidavit নয়, for filing a response to the supplementary affidavit.
Regulation.
The order dated 1st December 2025.
Regulation.
Paragraph. Learned advocate representing the school raises a preliminary objection with regard to the maintainability of the writ petition. Stop. It has been submitted that the school is a private funded one and
Trust
managed by a trust. Stop. The writ petition against the school will not be maintainable.
And quay the teachers, not at the instance of a
Quay
school.
the teachers. Yes. Next. According to the board, the writ petition will be maintainable before the court. Stop. The issue in the instant writ petition has to be decided upon exchange of affidavit. Stop. Let affidavit in opposition by the respondents be prepared and circulated within a period of 6 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Stop. Prima facie, as it appears that the termination of an employee cannot be order of termination of an employee cannot be issued or passed by the learned advocate of the institution. Accordingly, the communication of the termination of employment dated 14th July 2025 by the learned advocate of the school is set aside. Stop. Paragraph. All consequential relief on setting aside of the order of termination shall be passed on to the petitioner.
Now I have a submission.
Within certain time deep frame.
The advocate communicated a decision. The decision remains. Today, the advocate's communication has been, your lordship has been pleased to set aside.
Tomorrow the school will.
School is going to communicate.
I'll mention that. I'll take care of that also.
Kindly.
Any steps taken by the school during pendency of the writ petition shall abide by the result.
Right.
It goes without saying. Nevertheless, I have recorded that.
Subsistence allowance be paid.
Consequential steps বলেছে।
I am not making all consequential steps.
Make it time frame, otherwise.
The earliest, immediately. But did you receive subsistence allowance prior?
Prior to that,
যেখানে বললাম না যে his subsistence allowance has been stopped. এখানে এক লাইন add up করবেন. According to the petitioner, he received subsistence allowance prior to issuance of the letter of termination in July 2025. Yes, next.
Affidavit of service kept.
Please to extend the time to file affidavit.
In the main matter, because supplementary goes.
Supplement.
Main matter.
Yes.
I am for the petitioner, Lordship. Led by Mr. Hon'ble Justice. Last August, Lordship had taken up the matter and passed an order that directed SSC to file a report regarding this matter, Lordship.
Not filed?
Not filed, Lordship.
Kindly give it extension. 35 petitioners are there. 37
37 petitions.
are there. So
Why 37 petitioners in one read petition? What is the issue?
they were job losers.
All right.
And now they want to come back and participate in the upper primary, but that they did not even participate in the interview process. So now going so far back in time, that will not be possible. And there are several matters which have been dismissed on same prayer, but there are also appeals which are pending from those matters. So,
all right. On the prayer of the learned advocate representing the commission, seeking extension of time for filing affidavit. Is it an affidavit or a report? A report in the form of affidavit. Stands extended till 13th of March. 4 weeks will be all right with you? 13th March 2026. Reply if any.
13th.
Within
13th.
10th of April. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period.
Deeply obliged.
Next. What are the cans? Cans?
Can, there is no can.
Yes or no?
I think, Lordship, they are additional party in this matter, Lordship. The can is
party. Cans allowed?
Already been allowed, Lordship.
একটু দেখতে হবে প্রদীপ ক্যানটা কি ফেলছে না
বলতো লাস্ট মোমেন্টে হ্যাং করে যায় না
হয়নি না তার মানে ক্যান পেন্ডিং আছে চেক আপ হোয়াট ইট ইজ এই সিআইএস এ বোঝা যায় না ক্যানটা কিসের প্রদীপ
Lordship, I am for the petitioner in this matter.
What is the matter about?
Matter is relating to petitioner joined as a clerk through managing committee. Managing school is running under Article 30, Eastern Missionary School, and school was given appointment. Subsequently, petitioner moved an application before this honorable court, and in terms of this, in terms of the order, petitioner got approval and thereafter released the area amount. Petitioner is claiming interest on area. Petitioner got area amount on 14th February 2020, and upon this petition, 6th day of December 2024. In this meantime, COVID-19 period. So the Honorable Supreme Court passed an order relating to condemnation of delay.
There is already an order annexed at page 10.
Yes, Lord.
Directing the DI to approve the appointment of the petitioner. Has that been done?
The petitioner got approval, and
what do you want now?
After approval, petitioner received the amount, area amount.
What do you want now?
Interest.
Interest. From 12 to 18. When did you get your approval?
In terms of this order, Lordship, 23rd August 2018, and thereafter petitioner got area 14th February 2020.
What is your submission?
Mr. Rajlokhi Ghotok is appearing in this matter. He is not here. I am praying for not today only.
How can you claim interest?
Lordship, where principal amount is released, their interest must be paid, because interest is not a penalty or a punishment. In terms of the Honorable Supreme Court judgment, I have handed over. I will see the last. Last para, Lordship. Last page, last para. It may be mentioned that there is misconceptions about interest. Interest is not a penalty or punishment at all, but it is the normal accretion on capital. For example,
Even despite this, you say, why will you be entitled to interest? Next day, come prepared. Accommodation sought for on behalf of the learned advocate representing the state respondents. Stop. Released on 2nd of March. What is the application? Oh no, there is no application here. All right, next 26. Who is your other side?
Mr. Pradeep Pal, I have served notice to Mr. Pal.
What is the matter about?
The matter relates to interest on gratuity. A retired Malad in 30th September 2018, EPPO was issued January 2019 and revised EPPO was issued 2023, but the pensionary benefits was not released, and thereafter writ application was moved before this honorable court, and thereafter they released all the pensionary benefits. And your lordship may kindly have a look in the order, that is, it has been written that in relation to interest, Malad, it has been directed to make an application before the appropriate authority, and accordingly application was made, page 29, and that has not been released till yet.
Where is the page 29 is your application?
Page 29.
Please come.
Unless the mandatory order is passed, it shall not be released.
Prayer of the petitioner for release of interest on account delayed payment of pension and other pensionary benefits is pending consideration before the
commissioner, director of pension 134. That is the.
Did you not serve upon the district inspector of schools? He is the pension sanctioning authority.
Well, the state government, the government Peter is appearing for the DI.
Not the appearance. Where is the service of this letter?
Service of the letter.
Nothing. It's only upon the commissioner and the director.
But they have the authority to granting the.
No.
Is passing the
consideration before the commissioner of school education and the director of pension, provident fund and group insurance. It appears that the prayer of the petitioner has not been served upon the district inspector of schools, secondary education, North 24 Parganas, the pension sanctioning authority. Stop. Next. In view of the above, liberty is granted to the petitioner to serve the representation seeking interest upon the district inspector of schools, secondary education, North 24 Parganas. Stop. On receipt of the said representation, the aforesaid respondent shall aforesaid respondent shall take steps to consider the same in accordance with law at the earliest, but positively within a period of 8 weeks from the date of filing the representation. Stop. If the prayer of the petitioner is allowed, the necessary consequential steps shall be taken without any further delay.
If your lordship doesn't make it pending, the further litigation will arise. Had it been so, they would already been discussed. Matter is disposed of.
Yes.
This is the clear case. Your lordship kindly,
call the next matter, please. Yes.
The interest on gratuity, if it is not granted by a senior citizen person.
All right. Yes.
Well, the petitioner is not appearing.
Petitioner is not appearing?
Last occasion, nobody appeared on behalf of the petitioner.
Dismiss for default. Next.
May I come back on the next day, 28 and 30? May I just tomorrow? I mean Monday, my lord. May I just come back?
30, my lord. I am appearing on
28 and 30, my lord. May I just have some?
For the heat online.
28. I am.
May I just come back on Monday?
28 and accommodation has been sought.
Yes. Kindly.
Yes.
28 and 30 may come back on Monday, please.
Only not today?
Only not today.
Alright, not today.
On 28 and 30, my lord.
Alright, let us come to 30.
My matter is being quashed, my lord.
28, not today. 29.
29, but as for the petitioner, then let kindly come to the impugned order at page 66. Which according to me is without jurisdiction.
Alright.
But there's no scope for the interim order. If they want to use an affidavit, let them file, let it be hard out on merit.
So this is the final order passed by the court.
Petitioner was absent since 10 years, since 2014, without any application, unauthorized absence. In 2024, he made an
Alright, the order passed by the President Ad Hoc Committee.
After getting hearing.
West Bengal Board of Secondary Education. Dated 21st April 2025 is impugned in the instant writ petition. Stop. There is no scope for filing, scope for passing any interim order in this matter at this stage.
Yes.
Stop. The respondents are directed to file their affidavit in opposition within a period of 6 weeks, reply if any within a fortnight thereafter, liberty to mention the matter on completion of the aforesaid time period.
6 weeks.
May it be listed after 8 weeks.
You mention, let us see.
Okay.
6 weeks, 2 weeks. Next. 30 is not today.
School.
31. My lord, I need to appear in matter number 31.
And for secondary board.
My lord, the petitioner is a teacher in a Hindu school in Howrah. And the reason for filing this application is this. She was working in the post of teacher in charge for a long time. She has been removed from that post without following the procedure, principle of natural justice, and so much so that a charge sheet has been served upon her after she was removed from the post. No disciplinary inquiry, nothing of the kind. My lord, I have received the charge sheet after filing of this writ petition. Therefore, I am paying leave to your lordship to file that charge sheet by way of a supplementary affidavit today. May it be accepted? Yes. I am serving a copy. The supplementary.
No, just now I received the supplementary.
Yes. I don't object to that. If you want to take time, take time.
No, I am not talking about this.
My lord. Well, then may I place the facts in a nutshell? My
But without the supplementary affidavit being gone through, can the matter be taken up?
My lord, it is up to your lordship.
No, you say.
No, Lordship,
No,
this
I know.
is our difficulty, Lordship, without I don't.
They need to state what is there. Supplementary affidavit filed on behalf of the court. Petitioner in court today is taken on record. Copy of the same has been served upon the learned advocate for the respondents in court. The respondent seeks time to revert with instruction. Release the matter on 2nd of March. Stop.
What's the second no, Lordship?
2nd March. No.
4th is holiday, Lordship.
No, combined is
9th, Lordship.
9 March.
9 otherwise, ना 3-4 तो शिवरात्रि जुले छुट्टी. मार्च छुट्टी तो Lordship 9th.
9th of March.
ना 3 दिन छुट्टी तो second March तो हमारे दिन.
Matter is. Yes.
Yes.
But let them revert with instruction. They'll take some time.
Let's say I will give some time, otherwise I file a report or anything, Lordship.
No, report is not required.
Required.
Not required. Then we can post it earlier also.
No, Lordship, no, Lordship.
The board is answering.
But I am the answerable, Lordship. Board is also, but I am the Lordship district, so I am the Lordship. Charge sheet has been DI.
Who has issued? Who has issued the charge sheet?
The board has issued.
Board has issued, but Lordship.
Here is the petition by my learned senior is submitting that matter he has what is the prayer in the petition for setting aside the order of.
That's what your Lordship want to fix the matter, Lordship.
Then let me continue with the hearing.
Yes, Lordship.
There are matter hard.
The 5th, Lordship, 5th or 6th, Lordship. 3, 4, 5th or 6th.
9th of March.
9th of March. Subject to your Lordship.
I'm for the petitioner. Here the petitioner
has joined as an assistant teacher in the year 1990. After that, pay fixation was made in the year 1994. My only grievance is that one of the career advancement benefit has not been extended to me. I have made a detailed representation at page 51. So
That is pending.
that is pending. Let it be considered. That is my humble submission.
The petitioner's prayer seeking higher scale of pay.
No, my lord. This is
Page 51 mentions
page 51. There is
higher scale of pay.
no, that is not higher scale of pay, my lord. That should be
Fit under the career advancement scheme
for the first 8 years of service.
on completion of first 8 years of service. Stop. On a perusal of the writ petition, it appears that a proper representation from the petitioner is wanting. Stop. Next, in view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to file a proper representation highlighting her grievances. Stop. In the event such a representation is made, the same shall be considered by the District Inspector of Schools, Secondary Education, Nodia,
my lord.
in accordance with law at the earliest, but positively within a period of 8 weeks from the date of filing the representation. Stop. A reasoned order shall be passed and communicated to the petitioner. Disposed. Another line. If the prayer of the petitioner is allowed, the necessary consequential steps shall be taken without any further delay.
Grateful.
Yes, 33.
My lord, I am for the petition.
My lord, Mr. Rudran will be appearing for the state respondents.
My lord, preliminary submissions, my lord. Number one, my lord, this is second round of litigation challenging a speaking order, my lord. And the primary relief that I am seeking, my lord, is higher scale of pay, my lord, postgraduate scale.
Upon setting aside the impugned order.
Upon setting aside the
Where is that order?
impugned order, my lord, starts from page 39.
All right.
Now, my lord, it is physics. The issue at the core, my lord, is subject equivalence, my lord. I have done my postgraduate in applied physics, and the clashes with physics, my lord. Now, my lord, here
is there any scope for passing any interim order? No, because the main order is to be seen. And they will.
One thing I would like to show, my lord. If my lord is pleased to take up page 42. The very last annexure, my lord. This is a 2016 notification, my lord, of subject equivalence. And
physics includes MSc in applied physics.
Yes, my lord.
By the commission.
14.
Yes, by the commission.
So this should have been considered by the authority who has passed the impugned order. Then again, my lord, placed reliance upon, if my lord is pleased to take up 41. Page 41, that is the most operative part of the order, my lord.
Yes.
That is a notification dated 17th of November 2008. And my lord, I have completed my MSc, my lord, the last examination. That's the very first line in page 40, my lord. It is noted 7th August 2008.
So this does not have any retrospective effect.
Yes. Based on this November 2008 notification, my lord, I have not been granted the benefit. They are saying that in this notification, applied physics is not an equivalent subject.
All right.
So,
a minute. Did you check up the judgment delivered in the matter of Utpal Kanti Karan?
My lord, here I have some issues, my lord, that I have not been able to check up, and whether there is any subject equivalence notification before that, that I have not got, my lord.
All right.
So, my lord, if my lord gives me some time, my lord.
Well, the reasoned order dated 29th of May 2025, passed by the District Inspector of Schools, Secondary Education, Barakpur, rejecting the petitioner's prayer for grant of postgraduate scale of pay, is impugned in the instant writ petition. The District Inspector of Schools is directed to revert with written instruction. Released on 20th of March 20. Come prepared in the meantime.
And number 34 I am for the petition. My affidavit of service now.
Who is your other side?
But I have served me. Is my affidavit of service now.
You served. Are you aware who is appearing? Did you give the notice?
Windrila Ghosh.
Alright. For the state?
For the state.
Alright.
And I have served also. And my lord, this is a simple case. My lord, the petitioner is assistant teacher in bioscience. My lord, after that, my lord, the petitioner applied for admission in B.Ed course for 2016 to 18. That was not that was although allowed by the all other respondents, but teacher in charge did not allow that. And since due to that, my lord, the petitioner was then took admission in the B.Ed course for 2017 to 19. And that's why, my lord, the petitioner is not presently deprived of this increment. May I kindly see the one letter dated page 22. Page 22 of the writ petition.
Yes.
Yes, it was addressed to the administrator. Below that, my lord, through the teacher in charge. It was addressed to him, but he did not consider such representation. Due to that, the petitioner did not allow to do this admission for B.Ed course 2016-18. And due to that, my lord, kindly see the pay slips I have annexed, page 27.
So what is your submission?
My submission is that this should be considered, otherwise, my lord, the petitioner is regularly losing his increments due to the fault of the learned teacher in charge. The other authorities already approved his.
Did you complain against the administrator to the district inspector of schools?
My lord, I have that.
Where is that?
My lord, kindly come to page 20. And accept P5.
This is a prayer for NOC.
NOC, my lord.
This is different. The allegation that due to the inaction on the part of the administrator, you could not take admission in the proper session.
Page 23, my lord. Page 23 also.
No.
Here is a letter, my lord. That kindly see. That page 23 I am reading. And the third below অনুমতির কথা টিআইসি মহাশয়কে বলার সত্ত্বেও বারবার বলা সত্ত্বেও কোন রকম ব্যবস্থা গ্রহণ না করায় উক্ত বিএড কোর্সে ভর্তি হওয়ার সুযোগ থেকে বঞ্চিত হচ্ছি, ফলে অর্জিত ভবিষ্যতে ইনক্রিমেন্ট সহ অন্যান্য সুযোগ সুবিধা থেকে বঞ্চিত হব এবং প্রভূত আর্থিক ক্ষতির সম্মুখীন হতে হবে।
This is prior to your admission.
This is prior to my lord. No, after my lord I apply, my lord, the course is over, my lord. I did that.
How can that be? This is dated 2016. Your course got over in 2018.
2018 and 2017 subsequently I joined. 2016 to 2018 I could not join due to the fault of the teacher in charge.
Right.
He did not consider my application.
Right.
Subsequently, my lord,
You raise a complaint, proper complaint.
My lord, I raised this complaint before the administrator as well as the additional district DI. Everyone, my lord, it starts from page 20, my lord. Kindly see, I have expressly written that teacher in charge did not allow the petitioner to join.
And thereafter, what is your prayer in 20 and 23?
My prayer is that to B.Ed course ভর্তি হওয়ার জন্য প্রয়োজনীয় ব্যবস্থা গ্রহণ করলে।
Right. So that has already been allowed now.
That has not been allowed. That is why, my lord, I was not participated in the admission in 2016-20. I was constant to participate in 2017 to 19. Next year. And due to that, my lord, since it is that was the last year, that was, my lord, increment was not allowed, my lord. And I am still depriving of this.
The petitioner alleges that due to the delay on the part of the administrator of the school to accord permission for undergoing B.Ed course in the 2016-18 session, the petitioner is losing financially. Stop. The petitioner took admission in the next session 2017-19. Stop. Prayer has been made to direct the respondent authority for grant of increment upon taking into consideration the delay on the part of the now after taking into consideration and condoning the delay on the part of the administrator to issue the no objection certificate for undergoing the B.Ed course.
A teacher in charge.
As a TIC.
Teacher in charge.
Or not the administrator?
No, teacher in charge.
Teacher in charge did not approve. Administrator approved. Teacher in charge did not approve. Administrator also approved.
তাহলে উপরে যেটা বললাম না যে অ্যাডমিনিস্ট্রেটর ওটা হবে টিচার ইন চার্জ। ঠিক আছে? The petitioner has annexed certain communications seeking permission for undergoing B.Ed course stuff on a perusal of the said applications. It appears that the petitioner has already undergone the B.Ed training course, but at a delayed date on account of delayed action taken by the teacher in charge of the school in granting permission to the petitioner for taking admission in the course. Stop. Next. The instant writ petition stands disposed of with the observation that it will be open for the petitioner to file fresh representation highlighting her grievances, his grievances, disclosing all facts with corresponding dates. Stop. In the event such an application is made, the same shall be considered by the District Inspector of School Secondary Education, Purva Bardhaman, in accordance with the prevailing rules at the earliest but positively within a period of 8 weeks from the date of filing the representation. Stop. An opportunity of hearing shall be granted to the petitioner and the teacher in charge of this school for arriving at a decision in the matter. A reasoned order shall be passed and communicated to all parties. Stop. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken without any further delay. Disposed services taken on record. State is not here.
Affidavit of service fine.
Affidavit of service is taken on record.
The petitioner's claim for higher scale of pay. So-called the petitioner is the teacher of higher secondary section of that school. His approval reflects he is a teacher of higher secondary schools. He enhanced his qualification after the amendment of the control expense. So as per provisions, he is entitled. Rather than the petitioner's prayer was forwarded by the school authority, page 30, 30, not 30, that is the page 28, that was forwarded by the school to the DI for grant of higher scale of pay. Page 28.
Has it been considered?
That has not been finally, or no order has been passed, but DI has asked the school authority to certain documents. Reply to that, the DI school has submitted page 30, but no final decision has yet been taken.
The petitioner's prayer seeking higher scale of pay is pending consideration before the District Inspector of Schools Secondary Education, Howrah. Stop. Without entering into the merit of the claim of the petitioner, the instant writ petition stands disposed of by taking into consideration the petitioner's prayer by directing the DI SC Howrah to consider the petitioner's prayer for higher scale of pay strictly in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. An opportunity of hearing may be granted to the petitioner and the school prior to passing a final order in the matter. Stop. A reasoned order shall be passed and communicated to the parties. Stop. If the prayer of the petitioner is allowed, comma, the necessary consequential steps shall be taken without any further delay.
May I just indicate one thing? The Lordship has been pleased to dispose. I have nothing. I'm not standing in the way. But I put a question to myself, page 28 and 30. After the SP Gupta judgment, whether these documents are applicable, how they came to
That
this?
is the reason I mentioned without entering into the merit of the claim.
28 and 30, how they are entitled to get these documents after the SP Gupta judgment?
It is, I have mentioned that the court is not admitting the claim.
Before your lawsuit rises, would you also take up the second SST matter?
No. I do not know because I've got a hearing matter. Now,
There are four matters to job.
জলপাইগুড়ি কেন?
At two.
জলপাইগুড়ি because there are hearing matters and there are other matters also. একটু চেক করে নিন তাহলে কেন